State of Wisconsin versus Austin Chronister, case number 25 CF1231 and 25 CF2138. Appearances, please.
Ken Olsztynski for the state.
And good morning, Your Honor. Attorney Nicole Muller appearing for and with the defendant, Mr. Austin Chronister.
Okay, so there's a motion as far as a bill of particulars, is that correct?
That is correct.
Which no longer exists under Wisconsin Rules of Civil Procedure, and the procedure is no longer available in criminal proceedings. Court's going to deny the motion.
If the court's going to deny the motion under that grounds, which actually the case law says it's still under the court's authority, but I guess the court's authority is to deny it, then I'd ask the court to order the state to tell us what specific...
They don't have to do that.
So,
I don't understand. They have to explain their case to yourself?
Judge, this is a situation where they keep sending more and more and more in discovery. We had the exclusion order because they kept adding charges, decreasing charges. The human trafficking charges that they have charged with, they did not establish in the criminal complaint what specific element of the human trafficking count that they are proceeding on, whether it's harboring, whether it's forcing, whether it's enticing, all of those
We'll get an
things.
answer right now.
That's what I'm looking for.
Generally, it was harboring.
Pardon?
Generally, it was harboring.
Not generally, what is it?
Well, I have 4 different victims, for starters, so each one is a little different. He harbored each of them. Several of them in the charging information does delineate exactly the manner in which he used either force or coercion. I can go by count, but it says it specifically in the information. For count 1 in the case ending 1231, it reads in the information, by causing or threatening to cause bodily harm to any individual. For count, and that was the first case, one moment.
Well, if we could just stick on count by count, you're still saying by force, but what I need to know is that was it recruiting by force, enticing by force, harboring by force, transporting by force, providing to furnish by force, obtaining by force?
Harboring.
Pardon?
Harboring.
Okay. So do we have a date, a further date on this?
We don't at this time, so I just want to be very clear that for each of the human trafficking counts, that it's the gerund is harboring.
Yes, that's my understanding. After a brief glance at this right now, I believe it to be harboring. I believe that's what I charged under. However,
Going with that.
the causing or threatening to cause bodily harm to any individual, I believe, does change in the second case for the final count, count 6. That was done under trafficking done by any scheme or pattern or other means to directly or indirectly coerce, threaten, or intimidate any individual.
Okay, so what do we need, a pretrial date and a trial date?
I believe we can set that, Your Honor. I do have one thing. Last time we were here, I asked for clarification on one of the court's orders. Your Honor, this case had an arraignment date and a prelim date on the latest charged case.
Okay.
Your Honor told me to make sure I got all of the discovery to the defense by May 23rd. Otherwise, the defense could file a motion. The defense filed a motion and a proposed order to exclude all discovery after May 23rd. However, we continued to do investigation after May 23rd. We discovered additional information, and as counsel indicated, we've been turning over information as well as we've been getting it.
So all of that's been turned over?
I believe all that's been turned over, but we've still continued to do an additional interview that I know that counsel is most likely aware of at this point in time. One of the interviews was actually just completed yesterday. So we do have stuff trickling in, but I wanted clarification as far as these materials that we're now obtaining. Is the court going to exclude any and all discovery after May 23rd, or are we allowed to continue to turn over materials as we get them to use them for trial?
Second.
Thank
Well,
you.
Judge, then, but what's the deadline? Because what are we going to have the day before trial and they're
No,
still giving me stuff?
I'm going to do that. Okay? But please don't speak over me, all right? When is all the discovery or is it already been completed?
It has been substantially turned over, and I understand, obviously, if we run into a trial date and we're not able to access a phone due to either if there's a warrant status or one of the phones is currently trying to be accessed but can't, obviously it's excluded. We'll do everything we can to try to get that beforehand, but there's certain materials that we are attempting to either obtain a warrant on or obtain consent on to search. But by and large, I believe we have a substantial amount of it already done. But it's a lot of digital media that I anticipate that will be turned over. I think if the court were to give me until a final pretrial date and trial date, we could generally make sure that we get a substantial amount of it over, and then that could probably inform the court if there's one or two things hanging out that we know what it is. But for the most part, we have a lot of it turned over. There's just a handful of things here and there that I know are still in the wind.
Judge,
And
here's,
a handful of here, there,
Yes,
it's not going to work for the defense.
I
So
understand,
they need the complete discovery,
if I may.
whatever you're going to be using.
of course.
If I may, Judge, I just find the state's argument here today disingenuous because when we were in court, when the court made the order for the May 24th deadline, the state gave the same story. Our investigation is ongoing and we're still getting information. And that's why Your Honor said, well, when will you be done with your investigation? And the state said, please give us this time. You said, okay. You set the deadline. And now they're coming back saying, well, we're doing more investigation. And so it's not appropriate. We need more time. And they were given the time. This court allotted them. If they want to continue an investigation, then they should not have charged Mr. Chronister. They should have waited till their investigation was complete, so then all of the discovery would have been handed over right away, and we would be able to prepare a defense.
Thank you. I understand what you're saying. So let's give them a pretrial date and a trial date in branch 38,
Understood.
and let's see where that falls. We'll keep this.
Well, when am I going to have the new discovery? Because that's going to depend on.
I will tell you.
Okay, thank you, Judge.
All right, for jury trial, we can do October, we can do any week in October, any Monday?
Nope.
No? Okay. Any week in November? Other than that last week, the week of Thanksgiving?
I could do November 17th. It's just going to be dependent on to any further investigation the defense has to do, but November 17th I would be open.
One moment, I have to check. I anticipate I'll be on FMLA in November and December into the first week of January. I think starting the second week of November, but I have to double check. I know I would be available in October, but outside of that, I would be unavailable likely until close to the second week of January if we go
That
beyond.
doesn't work. The second week of January does not work. I mean, that's just too far off.
Okay. Were there any dates in October that worked?
No, my trial calendar is very booked for October. I could do November 10th.
One moment.
I have a trial in Green Bay that's supposed to start the 12th, but if this goes, then that will get bumped.
One moment. I believe I start FMLA that exact period of time.
You know what, put it in January. It's okay.
All right. All right, in January, we can do any week other than that very first one of New Year's.
I have the week of the 19th or the week of the 26th available.
That should be fine.
All right, any preference between the two? The 19th is to have to start on that Tuesday.
Then let's do the 26th, so then we can start on Monday,
All right.
if that works for the court.
Yes.
The January 26th, correct?
Yes, January 26th at 8:15 for jury trial. And do we want to set that as to both cases then?
I'm sorry?
Same date for both cases on that?
Yes.
Okay,
I will file a motion for joinder.
all right.
Well, if we can have we're going to need another motion hearing date then.
For,
Well, I'd ask that the state not be able to file a motion for joinder until I have all of the discovery, because that's going to be dependent on an argument against that. The state just informed the court that it intends on filing a motion to join, even though we've had this motion hearing date set. They haven't filed anything, but if they haven't had all their evidence yet, I don't know how I'm supposed to make a meaningful argument as far as why they should remain severed.
I believe we could probably do with the motion to joinder and the final pretrial date. This motion hearing date was always set for.
no, we'll do it before that date, before the pretrial date. And any and all discovery will have to be completed on August 25th by noon.
Thank you.
And Judge, if it's okay with the court, if I could submit a proposed order to that extent and then say and put in the language of the order that any discovery handed afterwards is not admissible. Unless it's exculpatory, obviously that should still be provided.
All right?
All right, go ahead.
Pardon?
What were you saying? All right, for motion hearing date, let's see. We could do something mid-September. How's the 17th, 18th, or 19th?
That should be fine.
The 18th or 19th, I may be in trial across the way.
I think you're better off putting it December because
No, if we could do earlier, that would be better, just so then we can prepare for trial, Judge.
the latter part of November then.
All right. How's November 19, 20, or 21st?
Since I'm on FMLA at that
Oh,
point in time,
yes.
could we do the first week or so of November?
How's November 1st, I'm sorry, 5th, 6th, or 7th?
The 7th would be, oh, no. We do the 6th?
One moment. That should be fine.
All right, November.
You know what, I have to see if that's a judicial conference.
And do we need a separate final pretrial date? We can start looking for that.
What?
Do you want a separate final pretrial date?
Yeah.
Okay.
Yeah, I can do January for final pretrial. We have the motion hearing in early November.
Well, why don't we just set it as motion hearing final pretrial, and then if we need another date at that time, then we can schedule it.
That works for me.
All right.
I'll tell Mieta to coordinate something like that, you can send, so then you guys can come to the office. You know, we'll still be at the office, so you guys can meet there when I'm gone. I mean, you could.
What was the date, November?
November 6th. All right, November 6th at 8:30?
That's fine.
All good. All right, the next date then will be November 6th at 8:30 for a motion hearing and final pretrial, and the jury trial is scheduled for January 26th at 8:15. And
Those will be in
both
branch 38. Pardon?
I was saying the same thing, in branch 38, and that's as to both cases.
In the courthouse.
Do we know which courtroom?
502.
502? Oh,
courthouse, yeah.
great, perfect.
502 of the courthouse?
Yeah.
And then, Judge, just so we don't have any further issues, I would ask that the court also order that if the state's going to change their position based on what evidence comes in as to what specific way that they're charging this under the human trafficking, if it's going to be something other than harboring, that they inform the defense by that discovery deadline.
I don't intend to change that. Obviously, it's a matter of how the jury would be instructed, not necessarily how a matter of it would be charged. I think that just goes to what instructions are included to the jury. I don't know that it matters.
All right.
Well, it matters for our defense. That's the whole point of my request. So I just am asking that if the state's going to be asking for a different jury instruction other than harboring, that be provided to the defense by that discovery deadline. It just changes how we have to investigate and present a theory of defense. Basically, what I'm trying to avoid, Judge, is a surprise of we go to trial and they go, just kidding. We're not doing the harboring and we're asking for this instruction instead. And we've then prepped a completely different defense.
What, doesn't the defense do that sometimes?
The defense? No, we don't get, we're not, they're.
I'm not talking about you
requesting that.
specifically, but I'm talking about in general. Sometimes they change their theory of defense.
Oh, sure, they might change their theory of defense, but if we're prepping, Judge, you have to remember these allegations span over a decade, really. And there's so many different things that if we're going to be prepping the defense for January to be under a harboring lens, that looks very different.
That's what they had said. Correct?
Correct.
Okay.
I just want that deadline for the discovery. If they're going to change it, that they have to do it before the discovery deadline.
Will you inform the defense if that's what it's going to be other than that?
Yes.
Okay.
Thank you.
All right, again, the next date is November 6th at 8:30 for motion hearing and final pretrial, and the jury trial is scheduled for January 26th at 8:15, both as to both cases and both before Judge Wagner, Branch 38.
Thank you.
Thank you.
Thanks.